Hey, Stephanie.
Hi, Don. How are you?
Good. We're back on our Legal Beagle network, looking to do a case review.
Yeah.
Marriage of Thompson.
Yes.
Okay, well, before that, do that, I'm glad that we're recording this conversation for future reference, unlike in court these days. Apparently, the L.A. Superior Court has taken away the court reporters for family law.
Yeah.
How do you feel about that?
That's kind of scary. We really rely on those transcripts for a lot of our, hearings. Let's say hearings continued. We rely on the transcript to continue on that hearing, to refresh the court's recollection, to impeach people. So it's a very important part of our caseload and our casework.
Yeah. So the government's not flipping the bill for what many of us think is justice in the American way, right? Making a good record. It doesn't mean that you can't have a court reporter in the courtroom, but unless you're able to pay for those hefty fees of having a reporter in there, guess what? You're going on the judge's memory and a minute order that's going to be pretty deficient if you're trying to look back at either what the actual orders were.
Right.
Sometimes even the judge can't remember what they ordered.
Totally.
Or what was said. If you're trying to impeach somebody, there's no record anymore.
Totally. When there's any dispute over a minute order, the first thing we do is order the transcript. So it's a little worrisome. I think as long as people are aware of the opportunity to pay out of pocket for one, and that we explain that to others, but it is a little concerning.
Yeah, maybe approach the other side and say, can we split the costs?
Right.
It's still going to be expensive, but at least half of it, Think about all the appellate problems that go along without having a record.
Exactly, and that's exactly what this appellate case, and that's, in order to appeal, you do need some sort of record of what happened at the trial court level.
Yeah. As a trial attorney, I was taught to always speak to the record. May the record reflect that the witness is holding one hand up and pointing to the sky, or, may the record reflect that the witness is looking away, from whatever it is and stuff. I mean, there's a lot of reasons to preserve the record during a trial, and if there's no record, it really takes away from our jurisprudence. I'm wondering if it was I think that they're going to say it was a cost thing, right?
I think so too. It seems like cost is a huge issue at this time. Maybe they're still kind of recovering from COVID times, or I don't know.
I don't know, because during COVID, I don't know what the tax base was. During the Great Recession, before your time, when the banks collapsed and everything, they cut a lot of services here in the courts. Some of the courthouses closed.
Yeah.
Some of them have been reopened. They stopped minors' counsel, the appointment of minors, or paid minors' counsel. You did away with they did away with the custody evaluators that were court employees that were doing that. Fortunately, most of that stuff came back, and it came back pretty quickly. I have to tell you, within maybe 2 years after they cut this stuff. I hope that the court reporter service comes back. Now, what we heard wasn't about cost; it was about the limited number of court reporters.
Right. So are there enough court reporters? I guess not. At this point, there aren't too many in supply.
That would be a sad commentary, because that's a great job.
It is. It is. My cousin does that, and there's a lot of testing and requirements, and it's hard.
It's hard to become one.
She actually worked on the Robert Durst trial.
Really? Oh, I didn't know that. Here in L.A. Wow, I didn't know that about your cousin. So, it's a tough job to learn. I mean, I've seen people try to take those courses and not,
it's like specialized keyboards and things like that. So,
but once you have it, it's a very flexible job and high paying.
Yeah.
So, anyways, we have a record on this case here.
We do.
Right. Okay. So it's Marriage of Thompson, and we're talking about jurisdiction. And I don't want to glaze people over with a jurisdiction issue, but I think this is kind of a good opportunity for people out there that want to know some of the basics regarding jurisdiction to cover this case, and you and I could discuss what happened. So why don't we set up the facts? Tell me what happened, and then we'll kind of parse it out.
Sure. So the parties were actually married, and they lived, and they had children in Massachusetts.
Great state of Massachusetts.
And then at some point, a husband's employer transfers him to California.
Okay.
So in California,
He goes by himself?
He goes by himself. My wife and the children stay in Massachusetts. Husband moves to California.
He's going to the land of sunshine.
He's going by himself,
okay.
ready to party. But he files He files a petition for legal separation against wife in California. He mails her a proof of service. He mails her the documents and says, hey, honey, can you sign this proof of service?
Why, sure I will.
She signs it, mails it back, he files it.
Okay.
Then wife decides, you know what? I'm going to file for divorce in Massachusetts.
I'm going to one-up you.
Yeah. This isn't a legal separation. This is a divorce in Massachusetts.
Let's stop right there. This is a point that isn't necessarily related to jurisdiction, or kind of sort of is. But we know that if she chose, she could have also done the divorce in California by simply checking the box on the on her response. She could have filed a response in California and said, I want this to be a divorce rather than legal separation.
And it would proceed as a divorce that
so
way.
she had multiple choices. She could have proceeded with a legal separation in California. She could have said, nah, I think this is a divorce in California. Or I'd rather have the divorce here in where I'm living right now. Okay, so she chose the latter.
She did. She did. And then husband says, you know what, now I want a divorce. So he amends his petition in California and decides to file for a divorce, dissolution. So at this point, wife personally serves husband in California with her petition for the dissolution.
Personal service meaning some process server came up and said, here you go.
18 years and over, not a party to the action. Here you go. Take these papers. You've been personally served. And that's considered proper service. So once he's been served, Massachusetts has jurisdiction over him.
You went right to the finish line here. We're supposed to build this thing up, man. Make it suspenseful.
Ignore the last sentence.
I mean, as hard as it is to make jurisdiction an exciting subject, but so here's what happens, right? He thinks that he's got jurisdiction.
He thinks.
Why is that?
He thinks because he's living in California and he filed first and he served first. That's his argument. You know, my petition for dissolution should relate back to my petition for legal separation. I served her immediately.
First in time.
First in time service. Right.
And why do you think that he was relying on that?
Because that is one of the main rules, right? Whoever gets served first that's usually the case that's going to lead, right?
If we're talking about competing jurisdictions, first to serve is usually the key.
Yes.
It's actually one of the things, as we'll learn in this decision, except in L.A. County. And I thought this would be something that our viewers who are interested in this subject should know is if you're litigating here in L.A. County, it's not first to serve, it's first to file. Yeah, which is nice. I like that.
Yeah.
Anyways, but it's still first in service, you know, if we're talking about competing states.
Yeah.
And in this case, you're saying that he filed first. He served her first.
Served first.
But what was the problem?
The problem was California does not have jurisdiction over wife. Wife lives in Massachusetts. Wife works in Massachusetts. They own a home in Massachusetts. And there's actually even a support order from the Massachusetts courthouse. So wife has zero contacts with California.
Okay, so let's talk about that. What kind of jurisdiction is that called?
So that's personal jurisdiction.
Or in personam.
In personam,
okay.
Yes.
So this is a big thing that we learn in law school in our first year, civil procedure, and it haunts you for the rest of your career.
It does. It really does. When I read this case, I cried.
Yeah. I mean, I remember International Shoe, Marriage of Culco. It's interesting. They're not citing the same cases they cited when I started, except for Malco. They had that one decision in there. But essentially what in personam jurisdiction means, it's the minimum contacts.
Minimum contacts.
What does that mean?
Minimum contacts. Where does a person live? Where do they work? Do they have any minimum contacts with the state for the state to acquire any sort of jurisdiction over that person?
Yeah, so did they avail themselves of the benefits of living in California?
Yeah, right.
And that would be something like, did they used to live here? Did they have a job here? Did they utilize the government resources?
Right.
Different than if they just came out here for a convention or something.
Right,
like
or a vacation.
Yeah. The fact that they had been in California, they visited Disneyland, would not confer personal jurisdiction, right?
It's not really enough, right?
Okay. Now, there's another way to get around that, though. Let's say that wife was here in California, and she was at Disneyland. And she's walking around the park, and she's happy as all heck, ready to go to the hotel, and husband goes, gotcha. Or a processor and serves her. So if you're actually served within the state, then you could confer personal jurisdiction.
Yeah, there's different ways where a non-resident could be conferred personal jurisdiction. That's one of the ways, if they're served in that state, or if they're domiciled in that state for a certain period of time when the action is commenced, that wasn't applicable here. Or even if the defendant agrees to personal jurisdiction, okay, fine, let's
Consent.
consent, exactly. But there just wasn't any of that in this case.
Okay, so in summary, husband is Johnny on the spot. He files first.
Mm-hmm.
He serves her by mail,
Mm-hmm.
and she signs an acknowledgement of receipt.
Yes.
Okay, so that's great. What happens if he had personally served her?
If he would have personally
Out of state,
served her
and she's out of state.
so he would have been first to serve, but I think the same
Analysis
outcome would have.
It doesn't matter if it was by mail or if it was personal
Right.
service, because again, what I thought was a telling thing here is proper service does not equate to jurisdiction.
Right,
You know
right.
what I mean? And we confuse that a lot of times, I think.
Yeah, right. So I think that's like the big thing. If there is concurrent states that have jurisdiction of both parties, then that first in time of service would govern.
Proper service, too.
Proper
right?
service. But in this case, California never had jurisdiction over wife. So technically, wife filed first and served first. And
Yeah.
that's-
Is that funny? It's one of the first things you learn in law school. You never stop coming across new cases like that. Do you know, was the husband represented by an attorney?
Ooh, I don't. But oh, yes, he was, because they did file a response to her motion to quash, and it seemed like a lawyer had prepared it.
So the wife, the way that she defeated this thing was by filing a motion to quash.
Yeah, so
right?
she files a motion to quash in California, basically saying this entire case should be dismissed. You guys don't have any power over me. And at the trial level, they agreed. They dismissed husband's case in California, so the case in Massachusetts was governing. That's
I'm wondering if there was ever any attempt by the husband to say, wait a minute, she's got the minimum contacts here in California. Because if he did make that argument, it certainly didn't surface on at the appellate level.
yeah, I don't see that in here. And he also did not contend that Massachusetts lacked jurisdiction over him.
Right.
So none of those really panned out. What he mostly argued was that by her filing the motion to quash in California, that was her appearance in that case,
Okay.
and that the court would have power over her at that point.
Okay. One last thing to talk about. Okay, so when he gets into California, rather than filing for divorce, he initially files for legal separation, right? A judgment of legal separation. And we won't go into it in this podcast what the difference between, although you've handled your fair share of those. Okay. But for a venue to acquire jurisdiction in California, there's a thing that's called overnight jurisdiction. That's when you file legal separation, because you just have to show, I was here overnight, I was domiciled here overnight, versus waiting the 3 months or
Okay.
6 months, right? I don't know if that's what happened here, is that why he did that. But I thought it was curious that he filed for legal separation while being out here in California.
It says that he filed in 2019, and he had been transferred. I'm not too sure.
Yeah.
I have to look more
We'll have
into
to
that.
give him a call.
I know.
Call the attorneys
I
that
have to
are handling
call
this thing.
John Richard Thompson and figure out.
Okay, well, that was great. I told you it was going to be pretty short and sweet, but
Yeah.
I think it was meaningful for our viewers.
It is really interesting procedurally, right? Because this kind of comes up a lot when, we file in one courthouse and another attorney files in another courthouse, and now we have two case numbers, and we kind of have to figure out how are we going to proceed from here?
Yeah, and I guess a very common question that comes up is, do I have to have been married in California
Right.
in order for a California
Right.
court to dissolve my marriage? And the answer is
No, because in this case, the parties were married in Rhode Island, and although it did not work out in California, it's for a different reason.
yeah. So what we know is that the jurisdiction has to deal with the people being in California or connected to California. You could be married in Transylvania.
Yeah.
So long as California has jurisdiction of both parties, it doesn't matter. So you don't need to bring in necessarily a marriage certificate
Yeah.
that you
That's
were married
really
in
rare.
California. Yeah.
Most of our clients are out of the country, out of the state. We don't need to be married in California to.
Conversely, if you're married in California, you could get divorced elsewhere, right? Please do. No. Okay. Thank you very much, and we'll see you next time.
Thank you.